This is the On the Pony Express podcast, part of the On3 network. Check out all the SMU coverage you need at ontheponyexpress.com. Now, here's your host, Billy Embody. 1, 2, 3, let me go.
Welcome in, ladies and gentlemen, to another edition of the On the Pony Express podcast. I'm Billy Embody. Thanks for joining us. We are back off of a bye week, and we have a lot to get to on this Monday, catching you guys hopefully in time for your commute home. We will have an interview with Alex Anderson, a lawyer who is an SMU alum and works for Pillsbury and Winthrop, which was a great opportunity for us to dive into the House Settlement, the Clemson, Florida State stuff. We'll do all these things. And for this entire interview, just enjoy it. You know, this is one of those opportunities where you get kind of an unbiased look at where things stand with the House Settlement with regards to revenue sharing and things like that. So we'll get to that a little bit later. But I did want to start out with kind of a look around the Hilltop in a way. SMU volleyball continues to roll, and we'll talk some recruiting as well. But first, I got to remind you guys that we are presented by our friends at StatusJet, statusjet.com. David Henry and his team continue to make it happen for SMU people. They were flying around Rhett Lashley and his staff on Friday night as they hit the bye week, and that means recruiting. They went out and saw North Crowley play where SMU has some prospects. Also saw the big Duncanville-DeSoto matchup as well. And that was all brought to them by StatusJet, you know, putting that together. A helicopter for Rhett Lashley to get into and scoot across DFW quickly and safely as well. So use code PonyUpACC to get ahead on planning the rest of these road games. The Duke game just came out, 7 p.m. Central, 8 Eastern over there in Durham in just over a week or so to that one. So get on them about booking your trip with them. They'll give you a discount with code PonyUpACC. So appreciate StatusJet for helping SMU fans fly in style. We lead off with the big news that SMU volleyball did shock number one Pittsburgh. They had only lost, I believe, one set all year, and the Mustangs went out and beat them in Moody Coliseum just days after losing to them during a road matchup for the volleyball team. So Sam and her crew has it going on right now as SMU has climbed up the rankings, now continuing their climb up into the top 25. And I think this is one of the, coolest things that's going on right now on the Hilltop is that SMU has wins over number 1 and number 2 Pitt and Nebraska this year. I believe they're the only team to have beaten Pitt now. And the Mustangs now sit at number 12 in the coaches poll on the volleyball side of things. So this is a really, really fun program to follow right now. So just want to give shout out to the entire SMU volleyball team and what they're doing. We're going to have Coach on podcast at a future point as well. We're getting that set up as they continue to show why SMU is a great add to the ACC. Coach Sam Erger doing her thing, building this program up. And this is a really exciting time for that program and everywhere on the Hilltop, obviously, with SMU football in the top 25 now at number 21 in the AP top 25, I believe number 23 in the coaches poll, and getting ready for a trip out to Stanford as well. So shout out to SMU volleyball for getting it done. That was a huge win on Saturday, just fresh off of a sweep to Pitt. They turn around and they beat Pitt in Moody Coliseum. So I think this is really, really cool for SMU to have it going on. And on Friday, SMU men's soccer did draw against Stanford. So something going on there with them to kind of note for you guys. So just kind of want to take a brief look around the Hilltop and kind of share where things are going on that front because SMU football is back from its hiatus after the bye week. And things are going to get really, really cooking here down the stretch for the Mustangs as they push for a college football playoff spot and a spot in the ACC championship. This is a team that is riding high right now. I know the bye week kind of gave everyone time to reset and get healthy, as well as the fan base to kind of take a deep breath from what's been a crazy 3-game stretch with wins over TCU, Florida State, and Louisville to cap things and push the Mustangs up into the top 25. So with that, on the recruiting front, things continue to kind of happen for the Mustangs, and we are continuing to monitor the 2025 class, just kind of months away from things kind of winding down and recruiting on that side of things, which will mean ultimately some clarity for SMU's coaching staff. And they did hit the road in recruiting, so I do want to share with you guys some of the stops that they made around not only the Metroplex but outside of it as well. We will have the entire list on the Pony Express on our Thursday Hilltop review. That is a huge new feature that we brought back from those of you who have been following me for a long time. We did that at Scout, did that at 24/7 for a bit there, and now it is back. And it's a huge, massive insider piece on kind of where things stand across recruiting and team and anything else we get. So it's a must read for you guys. We're going to try to drop it every Thursday for you guys. And it's a good reason to subscribe to ontheponyexpress.com. You can save with an annual subscription. People have really jumped on board. And I tell you what, guys, we're red hot. Just like SMU football right now, on the ponyexpress.com is cooking. We're at all-time high on all things page views, sessions for those of you, kind of website nerds, as well as subscribers and things like that. So it's a fun time to be on the site. The message board is popping, so jump on board. So I do want to lead off with one of the stops that SMU's coaching staff did make, and that was to see 4-star wide receiver Jalen Cooper. And Jalen Cooper did take an official visit to Notre Dame this weekend. He's one of the best wide receivers in the country. You could see On3 leading the way on him. He's a borderline top 100 prospect, 16th best wide receiver in America. Well, Notre Dame has come calling with an offer and has been recruiting him since the early portion of his senior season, and they hosted him for an official visit this weekend. And the Irish are pushing for his flip. He's returned back to Texas on Monday, so he and his family will talk things over, and we'll see where this goes. This is a prospect who kind of did some misdirection ahead of his commitment. A lot of people were thinking he was headed elsewhere, but quietly SMU had felt really good and positioned themselves to land his commitment, and he was a silent commitment to that staff, and carried out that commitment and went public in a big recruiting win for SMU to get the four-star wide receiver on the board. I think other ranking services are going to continue to catch up to On3 on him. He's really refined route runner. He's made big plays just about anytime he's been on the field between junior year and this year. And he's a really, really good prospect that SMU is trying to hold on. So Rob Likens, the SMU wide receivers coach, was out there for his game on Friday against Converse Judson, and the steel rolled. I mean, they're cooking right now. Chad Warner, the quarterback who's committed to, I believe, UTEP, has things cooking. He was on my list once SMU lost Keelan Russell to Alabama, and he's I think UTEP's getting a really good player if he signs there. Really productive guy that is getting the ball out to Jalen Cooper and really has him in a good spot. And so SMU is going to hear a decision probably in the next week or so from Jalen Cooper. And right now, I mean, it's a battle for Jalen Cooper. I'm sure you're looking at one of the prestigious programs in Notre Dame with their tradition, with their history. And it's just a different world too at the same time. And on the flip side of that, SMU's produced NFL wide receivers at a much better clip than Notre Dame lately. I believe Notre Dame's had 2 receivers drafted since 2010. I could be wrong, or maybe the last 5 years, which SMU has been cooking at the wide receiver position in terms of producing talent. And Rob Likens also has Brandon Ayuk on his resume. So this offense that SMU has, it is one that is also going to offer a lot of playing time early. They lose a bunch of wide receivers, and Jalen Cooper could be in line to play early with his technically advanced route running. And so that's kind of the battle that I'm sure he's going to face. He's a hardworking kid. He really is close with his family, so I'm sure he's going to lean on them. But on the flip side of that, South Bend, they're finding out how long of a flight up there it is to get there and things like that. So we'll see. We'll continue to monitor this. But Rob Likens did go out there on Friday before he flew up to see Notre Dame on that official visit, and just kind of showing him, hey, you are a priority. He was also on campus for the Florida State game. So we'll continue to monitor that as Jalen Cooper inches towards a final decision that should come relatively soon. And then SMU running backs coach Kyle Cooper hit the road, and he saw SMU's running back commitment Dremeco Green. Chunky is off to a huge start as a senior for Conroe. They're undefeated as well. So they're doing a lot of good things over there. And SMU is really trying to obviously keep, an eye on him as he goes through his senior season. He's really been productive, had another 100-yard rushing day last week on his birthday, which is when Kyle Cooper came by on that Friday. And it was a big commitment for SMU, another one that tried to kind of do some misdirection and leave people guessing. But the Mustangs had really held on there from the get-go and had done a nice job. And so we'll be keeping an eye on his development as a senior. I continue to, kind of send the film to our rankings team and just make sure he's top of mind because he's been really, really good. I think he's going to have a bright future at SMU. And with Brashard Smith leaving next year, the starting running back job will be up for grabs. And no one's on the roster is really taking it. Kamar Wheaton's hurt. Jalen Knighton will be coming back. LJ Johnson will be coming back. You do have Derek McFall, who looks like he's going to be a stud, but running back's one of those spots that maybe you let a young guy kind of go and make some things happen. So he's playing really well. And then Rhett Lashley did swing through, like I said, to see DeSoto and Duncanville. It wasn't the night for the DeSoto Eagles. They went down to Duncanville in a kind of a dominant showing by Duncanville. They were able to take control early on and just get it done. But Dalen Singleton, SMU's 4-star wide receiver commitment, a slot. He's going to be a really good player for the Mustangs. He was also in action in that game and took a kickoff return back for a touchdown, almost took another one back. There was a penalty, but had another big return. So teams keep kicking it to him. I don't understand why. He was kind of bottled up. It was a long day, long night for DeSoto trying to move the football, but he was seen by Rhett Lashley, as was Sael Reyes, the safety commitment for SMU that plays for DeSoto. And then on the winning side of things, SMU defensive back commits Javion Holiday and Tyron Polley were watched by SMU staff. Man, who's Tyron Polley, actually tweeted out or put on Instagram that it looks like he's got a foot ankle kind of deal. So that is something to keep an eye on there for him in terms of if he can get back on the field. But SMU's got really 4 really good commits that were in that game. So it made a lot of sense that Rhett Lashley was out there watching those. So look, we're going to bring you guys all the latest and greatest when it comes to recruiting in the team. So Hayden Howerton and I will be recording our weekly preview podcast as well later this week. We'll have Garrett Gilbert and Kyle Padron offering up their thoughts on things as well for the Stanford game. And then, of course, we recorded Walking Strong with Bill Armstrong last week, and we dropped that. So a lot of exciting things ahead for the Stanford game as SMU will be headed out there. But we'll be headed out there for our tasting happy hour at Epic Wines Friday night. So really excited for all of you guys in Paso Robles that are joining us. And without any further ado, we're going to go to our interview with Alex Anderson, but do want to remind you guys before that we are presented by our friends at AKM Turf and Greens. Use code PONYUP for $500 off your project today. Get your backyard looking pristine for entertaining this fall. It's cooling off. It's the perfect time to have people in the backyard hanging out, having a good time. And that's where AKM Turf and Greens can help you turn your backyard into such a great place to entertain. You can have a putting green, chipping green, whatever, but also just a space that is well-maintained and taken care of. So reach out to AKM Turf and Greens today. Go to email info@akmturfandgreens.com or go to akmturfandgreens.com today and use code PONYUP for $500 off your project today. Without any further ado, we go to our interview with Alex Anderson. I'm happy now to be joined by a proud SMU alum and one of the top lawyers in the country, too. He's not going to pump his own tires, but I will. Alex Anderson from Pillsbury joins us. Alex, thanks so much for the time. We've got a lot to talk about, but let's lead off with this. Your firm is one of the top in the entire country at dealing with and being around kind of all the things associated right now with the NCAA, whether it's different cases, um, being worked through with the House and things like that. Kind of lay the groundwork for everybody in terms of where Pillsbury fits in and your role and things like that, as well as your SMU fandom.
Sure, Billy. Thanks for having me on. It's great to be here. I'd like to consider myself sort of a longtime friend of the pod, first time caller in. Just to give you just a little bit of background, I am with Pillsbury Winthrop. We're a vault-ranked international law firm, about 750 attorneys worldwide. We've got big offices in Austin and Houston. I'm still pushing for that Dallas office. I really would love it if we had a Dallas location. We don't yet. I'm currently here in Washington, D.C. Was fortunate to get back to Dallas just a couple of weeks ago for the Florida State game. Had an awful lot of fun there. But we're a full-service law firm. We basically do everything under the sun, from IP work to wealth and investment planning and tax planning for sort of high-earning individuals, complex business litigation. Hopefully none of our listeners would ever need it. But personally, I do a lot of white-collar criminal defense work, internal investigations, government investigations. It's very kind of you to characterize us as being sort of at the forefront of things with respect to collegiate athletics, but I'm compelled to just bring that in just a little bit. I had the opportunity to work very closely with the chair of our firm-wide white-collar group, former AUSA, Bill Sullivan, and I've worked for him for 7 years now. But about 6 years ago, we had the opportunity to represent the University of Kansas as a defendant in the Southern District of New York criminal prosecutions of Jim Gatto, Christian Dawkins, Merle Code, and others who were either working for Adidas at the time or sort of in that space with respect to the FBI's corruption in basketball recruiting. Naturally, as everybody knows, what sort of arose out of that was a 5.5-year protracted NCAA enforcement action that was brought against the university. Assistant coach Curtis Townsend and head men's basketball coach Bill Self. And we were fortunate enough to be in a position where we had the opportunity to continue to represent the university in a supplemental role with other great outside counsel. But Bill and I had the chance to represent Mr. Self for 5.5 years through that enforcement proceeding with Scott Thompson of Thompson Collegiate Sports Law at Kansas City. He's just a tenacious bulldog of an attorney who has specialized in representing coaches for the last 3 decades. A lot of hard work, thousands of hours, but 5.5 years later, we got an absolutely great result from the NCAA's now shuttered independent accountability resolution process last fall in the form of a 160-page report that basically exonerated our clients in full, finding that Mr. Self had only committed the most minor infraction possible, a level 3 infraction, which we had already acknowledged to the NCAA had in fact occurred. Had an absolute blast doing it. Bill Sullivan did as well, and we're working very hard to turn that into additional business. We're continuing to stay active in sort of that sphere in collegiate athletics, but we've had to be nimble because, as you're aware and as our readers are aware, I can't think of any industry over the last 5 years that's undergone more sort of tumult or change. So you got to be nimble.
Yeah, and I think with all of that experience, just kind of, it's almost like that was the precursor to, NIL and what's acceptable and things like that. Like it was already in the works in a way, different ways to compensate student athletes, and obviously under the table for years it had been happening. But when you look at the landscape now, it continues to evolve. And, I really do want to get your opinion on and kind of, or at least not your opinion, but the where things stand, and kind of explain the House settlement, because we've raced past so many markers from worrying about this or that with agents representing different companies and interests to go after student athletes and pay them, to now what's essentially an open, just wild, wild west of paying players. And this House settlement is the latest thing that has come through. And for those who haven't been paying attention or kind of loosely following it, this week, Judge Claudia Wilkin did preliminarily approve the landscape shifting House versus NCAA settlement. It's right in the district court for the Northern District of California. And this was a big step in the process that is still going to be ongoing for quite some time. But $2.7 billion in damages will be paid out to thousands of athletes over 10 years. But also the revenue sharing piece, $21 to $22 million annually with athletes. So with that kind of at least brief stage setting, can you fill in some of the pieces of what all of this means and maybe what's next?
Sure. You did a heck of a job recapping it there. I mean, honestly, you stole about probably 90 seconds of me sort of teeing up what it is and where things stand. I'll try not to be too long-winded, but to understand where we're going, sometimes it helps to understand where we came from, because there's been so much change that's happened over the last couple of years. And if you go back to the 80s, 1984, there was a Supreme Court case, the NCAA versus the University of Oklahoma Board of Regents, where the Supreme Court actually did find that proposed television packages that the NCAA had put forward would run afoul of federal antitrust law. But in that opinion, Justice Stevens wrote, it's not even part of the case holding, it's kind of dicta, and I'll just quote it. The NCAA plays a critical role in the maintenance of a revered tradition of amateurism in college sports. There can be no question but that it needs ample latitude to play that role, or that the preservation of the student athlete in higher education adds richness and diversity to intercollegiate athletics is entirely consistent with the goals of the Sherman Act. Basically, what Judge Stevens was saying, even though it wasn't necessarily tethered to the law, is that this concept of amateurism is noble, it's important, it's something that should be lauded and protected, and the NCAA needs pretty ample latitude in order to enforce that and protect it. And so for the next 30 years or so, you kind of see that vibe, that feeling that he articulated, animating the way that the legal system treated the NCAA. The NCAA, in the end, is just a voluntary organization. It's a bunch of schools that have decided to get together and abide by a set of mutually agreed upon rules. Generally speaking, the law looks at those associations as you have the right to freely associate, and it's not the court's place to step in and tell you what rules or what procedures you should not have, or how you should do things. Of course, there are limits. You can't violate federal law. But at least until the O'Bannon case in 2016, the courts kind of looked at that and sort of said, well, maybe these rules do violate the Antitrust Act, but amateurism. That all changed in 2020, in June of 2020, when the Supreme Court handed down the Alston decision, which actually didn't concern NIL at all. It really concerned basically about $6,500 in education-related benefits that student athletes were eligible for. And what people like to cite to isn't even actually the majority opinion. Everybody likes to cite to Justice Kavanaugh, who had the concurring opinion, and I'm not going to bore everybody by spending too much time on it, but in a nutshell, he kind of looked at the NCAA and said, well, these issues aren't in front of us today, but kind of think that most of the rules that you're enforcing might violate federal antitrust law. And we don't have to rule on that today, but if we did, the NCAA is not exempt from federal law. Less than 2 weeks later is when the NCAA rescinded its longstanding prohibition on student athletes being able to generate personal revenue through their name, their image, and their likeness, NIL. And then, as you correctly noted, it was kind of a free-for-all. For the next 2 years, the NCAA really just completely withdrew itself from the issue. It issued a couple of pieces of interim guidance and some PDFs that had FAQs and sort of suggested to schools what was permissible, what could be done, what couldn't be done, but they were vague, they were high level, some of them weren't necessarily consistent with one another, and it was sort of interpreted as, we're throwing our hands up, you guys figure it out, let the states handle it. At the same time, right around the Alston decision back in 2020, Jeff Kessler brought a federal class action antitrust lawsuit on behalf of Grant House, who's a former Arizona State swimmer, and some others. And then 3 years later brought two companion cases, and just at a very high level made the argument that various NCAA rules, restrictions, and prohibitions constitute restraints on trade and violate federal antitrust law, and that the class is so large and the damages are so large that we're going to go to court and we're going to get a judgment that's going to be worth many, many, many billions of dollars. Fast forward to earlier this year, and as has been just excellently reported, principally by Ross Dellinger of Yahoo Sports, the parties to the House and its companion cases, which are Carter and Hubbard, it's the NCAA, and it's the five power conferences, the ACC, the Big 10, Big 12, the SEC, and then, believe it or not, the Pac-12, Pac-2, Pac-12. Basically came to a settlement agreement that was reported way back in May. It had been in works for months. There were sort of term sheets that were shared with certain members of the media. In July, the parties filed with the court sort of their long form agreement, which fleshed out the damages, as you correctly characterized. You're going to have $2.78 billion that are going to be paid in damages retroactively over a 10-year period to student athletes who should have been entitled to compensation. And then, of course, you have the forward-looking relief that the settlement is going to entail, which is student athlete revenue distribution, and then attempted restrictions on third-party NIL, and then a number of roster constructions, et cetera, et cetera. So that kind of takes us from where we were to where we are right now. As you noted, Judge Wilkin just approved it on Monday. It's not the end of the process. She set a hearing for next April. So we still got a ways to go.
Yeah, next April. I mean, what is being worked out between then and now? Are there conversations between the two sides, and then they present something to Judge Wilkin, or what happens between now and then, I guess, with this? Because there's a lot of pieces I saw just before we jumped on. Baseball rosters now expanding to 34 players, which is going to kind of, I believe, kind of crush mid-major high school baseball recruiting for colleges in terms of the rich are going to get richer. Your LSUs, your high-level baseball programs are going to be able to take more kids, and it's just one of the different impacts that under the roster construction are going to change. But that seemed to be one of the agreed upon things that they talked about, just at least preliminarily. What else fills in the gap during that long run till the spring?
It's some of that is sort of not really legal insight, how schools choose to move forward in terms of how the courts look at it. And it's kind of that delicate balance. Like right now, student athlete revenue distribution is going to start next fall. So schools, everybody is sort of attempting to figure out, what are we going to do with that? Even though the settlement has not been fully and finally approved and won't be approved until then, you still have to make plans, and those plans have to account for a bunch of different factors. It's a great opportunity for me to also just throw in, you should always beware of a lawyer who says he knows everything about everything. I don't. I am not a class action lawyer. I'm not an antitrust lawyer. I'm not a labor lawyer. I'm not a Title IX lawyer. Great thing about Pillsbury is we have all those things. I can, Jeff Metzer for Title IX, Andrea Milano for labor, but I'm doing my best not to speak too authoritatively on sort of the settlement process from a class action perspective, just because, it's not my forte. But I can promise you that right now, universities across the country are sort of making plans for that. How are we going to budget for it? Are we going to voluntarily assume that the student athlete revenue distribution is going to be subject to Title IX, which is going to impact the amounts that go to male student athletes. It's going to impact the amounts that go to female student athletes. How are we going to make those payments? Are we going to simply, have our student athletes come in once a month and write them a direct check that sort of says from Louisiana State University to Bob Jones, $3,700 revenue distribution? Are we going to have them enter into exclusive name, image, and likeness agreements where the school would compensate the student athletes using revenue distribution, but it would be sort of characterized as payments for the right to use their name, image, and likeness? Are universities going to engage a preferred third-party collective that sort of they have a relationship to administer it, or in certain states, based on state law, have the collective sort of act as a marketing amplifier for their student athletes? Are they going to cut sports? How are we going to fund certain sports? How many football scholarships are we actually going to fill? How much revenue are we going to distribute? You don't have to take part in it. And it's also not limited to the power conferences. If UTEP decided, if Memphis decided, if Tulane decided that they wanted to distribute revenue under the terms of this agreement, the rules will have to change. The NCAA will have to change the rules, their rules, to comport with it. Obviously, a G5 school will likely not be able to distribute the full $22 million a year, which is going to go up, but they can. And so they're having to prepare for it as well. They're having to adjust to the roster limits as well. And so those specific issues aren't strictly legal, but even though the settlement has not been approved, and technically it might not, schools are and have to prepare as if it will be, because it's going to be here before you know it. And the changes that have to be made, you can't just flip a light switch on Friday and come in on Monday and expect to change the whole way that collegiate athletics works.
And the enforcement of this eventual situation we're going to be in, what could that look like? I mean, is it something the federal government takes charge of? Does it fall back on the NCAA and they get told to go back to the drawing board on how they monitor what is legal, what's not, and things like that?
Sure. It's fuzzy and it's interesting.
On brand.
The focus has been on revenue distribution moving forward, and then an attempt by the NCAA and its schools to change the way that third-party NIL collectives are compensating student athletes. I don't think it's spilling any tea to suggest that a lot of people in the industry, rightly or wrongly, think that a good portion of NIL between when the prohibition was rescinded and now has been sort of a wink and a nod, pay for play. It's not express, but I'm not saying that's my opinion. I'm just saying I think others have said that. So originally, in the settlement agreement that was reached and filed with the court, any NIL deal with a third party that's $600 or more would need to be reported to the school. And the process that was contemplated was that those deals would essentially need to reflect market value compensation for the actual use of the athlete's name, image, and likeness. And they proposed setting up sort of a third-party clearinghouse, which means other people are going to make money, to vet these deals and examine them and say, okay, let's just stick with LSU and Bob Jones. Your local Ford dealership wants to pay you $376,000 and give you 6, brand new F-150s. That goes through the clearinghouse. I would imagine that somebody would look at that and say, Mr. Jones, you're a heck of an athlete, but we don't necessarily think that is reflective of true market value for the services that you're going to provide for the Ford dealership. So we're not going to bless it. And then the contemplated resolution process is you would then go before a neutral arbitrator, which many people might know, but some might not. It's in the legal industry. It is a third party, typically either an active lawyer, retired judge, that is brought in typically on panels, but it can be a single arbitrator to hear evidence from both sides and make a decision. And it can be what's called non-binding arbitration, where the arbitrator renders a decision and you're not bound by it. And then there's binding arbitration. And typically, you see these in contracts. You agree to what is called alternative dispute resolution. You don't just run to court. You say, we're going to use arbitration, which is, it's a little bit more collaborative. It's a little bit easier going than sort of court and the attendant rules for court. And we'll try and work it out that way. And so the agreement contemplates having a neutral third-party arbitrator decide whether the clearinghouse was correct or whether the NIL deal is fine. And then there are parameters around that in an effort to limit the harm. I actually take it to limit the harm to the player in question. I believe one provision is that if the arbitrator at the end of the day says, no, this is not a valid market value NIL deal, then the player can agree to essentially exit the contract without suffering any penalty in terms of eligibility or sort of other penalties. Interestingly, the settlement process experienced a hiccup there. The parties filed the papers with the court, and they went to a hearing before Judge Wilkin a few weeks ago to try and get preliminary approval, and she found this dispute resolution mechanism in the attempt to sort of assess what real market value is for an NIL deal to be pretty problematic. She said, go back to the drawing board. I want you to come back in 3 weeks. I want you to file papers explaining to me why this isn't a real problem. I'll see you on the 26th. And so the parties went back, and they basically they filed about a 32-page brief with Judge Wilkin, which it did two things. One, it did amend the scope of those who would be subject to the NIL restrictions. And two, it's pretty irrelevant to us. It basically explained, dear judge, in this context, you really only need to do these things. Don't overthink it. But originally, the sort of NIL prohibition, or we'll call it compliance mechanism, was for boosters. A third-party representative of an athletic department's interest, which is a very broad term. I'm a booster. Pretty sure you're a booster. Anybody that contributes to Pony Sports DTX, which everybody should, are boosters. And they basically amended the language to create a new defined term that is somewhat more narrow than that. But, big picture, it's still the same thing. If you enter into a third-party NIL deal, it's more than $600. You got to report it. It's going to go through the vetting process. They're going to assess it. And then there's this arbitration dispute resolution mechanism. It's not handled by the NCAA or the enforcement staff.
Is this, and probably the last question I have on this, unless you have other pieces that you want to add in for context, but where does the NCAA stand long-term in a sense? If or does this basically, or would this take away all of their power in terms of enforcing any rules, and they just become kind of a managing, all right, we're going to kind of keep everybody just on track here, TV deals and whatnot?
So the trick here is to not say something that could be demonstrably wrong in a month or 6 months or 6 years. I mean, anything can happen.
Yeah.
I've seen and spoken to people that said, boy, the NCAA is just going to fold up shop and disappear. The NCAA has a long and proud tradition of existence. It might change the way it does business. It might be less powerful. It might be staffed by fewer people. It might ultimately have to cede governance to sort of the autonomous conferences. And again, we're now sort of in sports administration. And it's adjacent to the law, but it's more sort of sports and business management. The enforcement role will certainly change and be more circumscribed because, for 80 years, the most complex and difficult cases, the ones that, get us involved, are the ones that involve the provision of improper benefits, be it products or money under the table. And, where there are rules, people will look to break those rules. That's human nature. But the last 3 years has taken a lot of that sort of above board. I was talking to, this is a while ago, but I was talking to, an attorney whose opinion I value a great deal. And, he said it wouldn't shock me if the basketball corruption cases that went through the IARP, Louisville, North Carolina State, KU, are sort of the last of their kind in terms of the complexity and the costs and the length of time and frankly, the adversarial nature between the NCAA and then the individual schools. Because sort of as you alluded to earlier in the podcast, those cases really are what's going on now, just it's legal. So yeah, I think the NCAA's role is going to change. I think its enforcement capabilities have already been curtailed and they may never get them back. I mean, before the House settlement came to light, you had multiple actions that were brought by state governments like Tennessee and Virginia that alleged in court that you can't enforce your own rules related to NIL because they break the law. And those cases, for the most part, weren't resolved. I believe the one with respect to the transfer rules in West Virginia was, but the Tennessee and the Virginia case, it's still ongoing. And once the court granted an injunction, which in lay terms means you can't do this thing that you were doing, they said, we're not going to enforce the rules, and we're not, and the NCAA came out and said, we're not even doing any NIL investigations right now. So it already has changed. I expect it to change more. I am having trouble seeing a future where we go back to the days of, this robust enforcement staff that's looked at as just this fearsome beast that's after you to get you. But I mean, crack open the NCAA rule book. Even if you change all these NIL rules, it's hundreds of pages long. I mean, there's plenty of administrative compliance work that can still be done, absent, bigger governance changes.
Speaking of something that could be changed if a certain ruling comes down, grant of rights, and that is under attack by Clemson and Florida State, and a lot of SMU fans are keeping a very close eye on that case. And
I'm one of them.
You and me both. And it just seems like one family feud, even though they're definitely not necessarily family at this point, about the overall validity of the grant of rights and the exit fees. And in particular, you guys had a rundown of the Clemson side of things. And can you kind of put into perspective where things stand right now? Because the gist of it from my perspective is don't believe the grant of rights is real, basically, and it shouldn't hold up in a court of law, and we're going to challenge it. And we don't believe we should pay the exit fees because of it.
Sure. Just sort of laying the groundwork. I'm not personally involved. I don't have access to, any of the documents. So I'm doing my best to sort of read the tea leaves and read the information that's publicly available. The lawsuit in South Carolina took an interesting approach in sort of saying we think that the agreements and the grant of rights are valid. We just think that you're not correctly interpreting them and that the scope of that is more narrow. The lawsuit in Florida, while it's taken a number of legal positions, spoke more to no. It's not enforceable, at least as against us and perhaps other schools in the conference. There are countersuits. It's a long way from being resolved. I have a little bit of trouble seeing how they establish either that they're misreading the scope of the grant of rights or that it's not valid. But funny things happen in litigation. You never, ever promise something categorical because you don't know what's going to happen. And where we are right now, I kind of think that the more interesting aspect of it is people like to talk about, settlement. And when the lawsuits were filed, a lot of the Twitterati and others said, oh, well, lawsuits always get settled. 97% of lawsuits get settled. What's going to happen is they're going to fight for a while, and then the conference is going to say, okay, we'll let you out for, X number of dollars, and then they're going to go. Well, you got to have both sides want to settle. And when it comes to we get out and you get money, others, not me, have, I think, pretty smartly observed that the conference might not be very interested in that, because once you have a figure that's been set, which is always less than what you claim it is, because that's settlement. Settlement is a compromise. You acknowledge that both sides have risk and you want to avoid those risks, and so you come to sort of a mutual agreement. It just puts a blueprint out there for perhaps other members that might be interested in taking their talents to another conference. But fast forward to a couple of months ago, and all of a sudden, it's leaked through the media that, well, they're being presented with sort of revenue models, and perhaps there could be an arrangement where they stay, but the revenue distribution is changed. And it certainly doesn't seem like anything is imminent. And I'd also note that these lawsuits, and many of the ones involving the NCAA, are kind of unique, because typically this stuff is intentionally all done behind closed doors. Mediation, confidential. Settlement talks, confidential. There are rules that apply to lawyers. Anything discussed during settlement as a general matter is not admissible as evidence, because the whole point of it is to sort of speak openly and speak freely to try and resolve your differences in an effort to avoid having to go to trial, or to avoid losing. But here there are so many parties and so many individuals that work for those parties that it's almost impossible to sort of keep those things quiet. It's much broader than if you just have a traditional dispute. You get a few people in the room, you talk through it. They're not going to run to the media. Here, again, you've got dozens and dozens of people who are sort of aware of these things. But if there could be a resolution that perhaps generates a little bit more revenue in terms of from the existing media contracts, because the media partners may be, they're certainly aware of it, they may be involved in it or a part of it, or maybe the revenue distribution has changed somewhat. I don't even want to put sort of a fence around what that might look like, but that to me strikes me as theoretically a resolution that might be palatable to both sides. Yeah, in theory, the give and take could result in an amendment to the documents that has the grant of rights terminate or adds a look in or something like that. But just kind of giving it my third party assessment, that could be palatable, I think, to both sides, because you're keeping it intact. Maybe there's a little bit more money. You put this dispute behind you. You get to focus on things, moving forward. It's a distraction. All those things that kind of go into the calculation. So maybe something gets done on that front. But Jim Phillips was just speaking to reporters in the last couple of days, and he seemed to indicate that I wouldn't expect anything soon.
Yeah, he said that they are ready for a lengthy process on that. So I think he comes at it from a point of confidence, which why would he not, with, Clemson and Florida State, and it might have been just one or the other, but even proposing, hey, what about this, instead of just trying to just continue the process through the courts and things like that, feeling like maybe they can get a judgment that works for them. And it's another piece that, and again, wouldn't be trying to paint you in a corner or anything like we talked about, but if the grant of rights is successfully, torn down in a situation in a state or in one of the courts, it would have massive ramifications across college football. It would potentially open the door for everyone's grant of rights. And is that something that a judge would even factor in? Like, if I do this, everything's up for grabs.
Ooh,
I know.
I think you're gonna get me on a tangent. If I'm the judge, I don't care. My job is to apply the law to the facts that are before me. That's it. I mean, they're equitable arguments. I think both sides have made arguments based in equity, which is more sort of a fairness argument. It's not necessarily that, well, this is what the contract says, but it would be unfair to allow one party, fundamentally unfair to allow one party to do this or not allow the one party to do this. But if I'm the judge, no, I don't care. If, and I'm almost not even speaking to the particular documents at issue, but if I had something before me and they said, well, this contract was drafted in a certain way and this is what it means, and if you were to find otherwise, it's going to have all these terrible ramifications, and they're wrong, my response is, this is what the law is. This is what the facts are. This is what you wrote. You're telling me something else, but this is what you wrote. And of course, it's difficult to sort of give the elevator pitch, but it's not just what you wrote. If the agreement can be read in more than one way, more than one reasonable way, then you get into how did they come to that agreement? Sort of facts concerning the negotiation, what the parties intended. To your point, the sort of the preamble that I think the ACC put in its countersuit or one of its moving papers was essentially quoting the president of one of the universities talking about what the document meant. That's public record, so it's already in there, but that's a good example of how one party might understand the agreement that they entered into. But I can't tell you what a judge would do. I would hope that they would do their job, which is to apply the law to the facts and, not worry about anything else.
When you assess where, this case is, if you can, I mean, can you share anything on how long this could go? Even if I guess a decision came early next year, you're still looking at appeals and all of this being, drawn out.
Yeah. For example, in the case in Florida, Florida State moved for partial summary judgment. That doesn't even resolve the whole case. Even if they were to win, and there's briefing on that, and then the court will typically sit on it, and they have oral argument. It takes a while to issue a decision. That won't end the case. I mean, they asked for judgment in their favor as a matter of law on an important point, sort of the enforceability and scope of the grant of rights, but it still wouldn't end it. There would be an appeal from that judgment. You would still need to resolve the other parts of both the lawsuit and the counter lawsuit. And then, some of it's been hung up and dragged down by the fact that they're arguing over sort of which court should have first bite of the apple in terms of who filed first, where the dispute really is held. Those considerations go into it. But absent sort of the skies parting and everybody sitting down at the table and holding hands with one another, I think it's safe if SMU students wanted to go ahead and book their trip to the Spartanburg, South Carolina area next year. I am.
I will be there. I will be there. And sorry for whoever is dumb enough to plan a fall wedding that weekend. It will not be attended as we've had a run of weddings. We're done with them. So, well, do you have anything else to add that we didn't hit on that maybe you want to mention? I mean, we've covered a lot of ground over the last.
We have, and you know what? We can. A couple of things. One, I did want to acknowledge that I feel extraordinarily out of place. That the guests that you have had on, Shane, Hayden, bringing in Kyle and Garrett's podcast under the 1911 alumni group, Mr. Miller, Mr. Armstrong. I'm just the simple caveman lawyer who's sitting in Washington, D.C. So I am humbled by the invitation to be able to chat with you about these things, when you have much more interesting guests on. I'm also fascinated to see how much lower the ratings are than, say, one of your walking strongs, to see us drone about the law for 40 minutes.
Oh, just wait till I throw a thumbnail over it that says Clemson, Florida State, like sinking ship lawsuit. Oh, it's going to have thousands. Don't worry.
But provided you don't turn off the cam and go, oh man, that was rough. We can always get together again as these things develop, whether it's in the lawsuits or whether it's respect to sort of the finalization and implementation of the House settlement. I hope that I've helped in explaining some of the concepts in an understandable way, because a lot of people, even myself, when I first started learning and understanding these things, it's very confusing, and it's not something that is easy to sort of inherently understand. I think people easily grasp as a concept, okay, they're going to get money. Well, what does that look like? There's still a ton of issues that have not been resolved, that are sort of critical to the governance of collegiate athletics and are really going to change what it might look like. The House settlement only resolves those lawsuits. Now, it's got a really creative provision that sort of automatically waives future claims that a student athlete might have unless they affirmatively choose not to be a part of the settlement. But outside of that, there are still other lawsuits that are going on. For example, there's a case in the District of Colorado, Fontenot. The NCAA tried to fold that into this settlement, and the court said no. Its allegations are somewhat similar in basically alleging that restrictions on NIL to include media distribution rights violate federal antitrust law, specifically what's known as the Sherman Act. That's not resolved. The attorneys general's cases that I've cited, those are not resolved. The issue of whether colloquially, a student athlete is an employee has not been resolved. This year, basically a regional director for the National Labor Relations Board determined that the Dartmouth men's basketball team are in fact employees. And the way that she went about her decision, even though Dartmouth does not award athletic scholarships, even though Dartmouth loses money, even though Dartmouth does not necessarily soft compensate its players at the same level as an SEC school, the analysis that she went through said, I don't care. You control their schedule, they're employees. But the National Labor Relations Act only applies to private schools. It doesn't apply to public schools. So even if her decision is affirmed by the higher board and then a federal court on top of that, that only applies to private schools, not public schools. But public schools are subject to federal and state public other employment law. All those issues need to be resolved. Ultimately, I think Charlie Baker, who's the president of the NCAA and who has a very a difficult job, has acknowledged that the goal here is to settle these cases and demonstrate to the United States Congress that you have not been willing to work with us and you have said unkind things about us and said we need to do better. Well, we are. We settled these cases. We're distributing $2.8 billion in damages. We're going to be paying student athletes moving forward. We've offered them, all of these tools with respect to helping to obtain better NIL deals. We're working to improve insurance coverage and healthcare coverage, but we can't do it alone. Please, please, please pass a federal law that does some combination of the following. Exempts the NCAA from basically federal antitrust claims, defines players as something other than an employee. And maybe that looks like creating a new term at law, essentially a bill that says, if you play intercollegiate athletic sports and you sign these documents, we will define you as a student athlete and you have limited bargaining rights, but you are not recognized as an employee. And therefore those cases go away, or provide some sort of national standard with respect to name, image, and likeness, because we can't completely eliminate it with respect to third-party collectives, and different states have different laws. We want everybody playing on the same field. We can have 3 or 4 more podcasts on all of that for the 3 people that have not been put to sleep already.
Well, hey, we'll do that again. This has been incredibly informative. We really appreciate your time. We're going to post some additional links and work that you guys have put together as well below this podcast for On the Pony Express subscribers who want to read and have another avenue of gathering information on things in the past and where things are maybe going, and just where things stand overall. But, incredible work shedding light on what is a very murky time in intercollegiate athletics. Keep up the good work, holding the fort down on the East Coast, and we'll see you in Charlottesville.
Thanks, Billy. Thank you so much for having me on. I listen to every podcast. Don't get rid of your audio ones. It's what I listen to at the gym. I really hope our listeners actually enjoyed it, and that I didn't just, make a fool out of myself.
Well, imagine how much work you could get done in the gym if you weren't putting yourself to sleep. So appreciate you jumping on, Alex, and have a good one. And everyone out there listening to this edition of the On the Pony Express podcast. We'll catch you guys next time.
Thanks, Billy.
Thanks for listening to the On the Pony Express podcast with Billy Embody. Follow us on your socials on X at SMU3 and on Instagram at On3SMU. And keep it locked to OnThePonyExpress.com for more coverage.